That said, let me very sincerely, on behalf of the 10th Rivers State House of Assembly, thank the Court of Appeal for standing by our democracy. Nigeria is a country that is governed under democratic tenets. What the Court of Appeal did today is to reaffirm our faith in this country, to reaffirm our faith in this country's democracy. So we thank the Court of Appeal for the interpretations they've done to some of the legal issues, to some of the matters concerning the Rivers State House of Assembly and, of course, Rivers State in general. So we thank Mr. President for what he's doing for this country. Again, we must say thank you to the President's Cabinet, particularly the Minister of the Federal Capital Territory, for what he's doing in the FCT, giving Mr. President the support that Mr. President deserves to continue to put this country on the path of fast development. So we thank the FCT Minister for what he's doing in supporting Mr. President and for what he's doing for the peace of Rivers State by being the political leader of Rivers State.
And indeed, that's where we're kicking off the conversation from that matter at the appeal court yesterday. Joining us to have this conversation, we have Mr. Chidi Lloyd, former member, Rivers State House of Assembly, a former local government chairman, a lecturer at the Department of Private and Public Law, University of UNEC, that's University of Nigeria, Enugu campus. Thank you for joining us, Mr. Lloyd. I'm not sure whether you graduated from the UNEC, but since you're lecturing there, let me just say, I greet you, fellow Lion. But let's go straight into the matter of that. Yes, I can hear you. Can you hear me?
Yes, I can hear you. Can you hear me?
Yeah, I can hear you. Okay, so that matter yesterday at the Court of Appeal. Now, that judgment based on Section 272(3) of the Constitution. Let's hear your reaction. We've already heard from Mr. Ameule commending the appeal court for that ruling. But let's hear from you, Mr. Lloyd.
Thank you, for having me, and thank you. Good morning, Nigerians. I'd like to start by making a few corrections to your intro. I am no longer a lecturer at the University of Nigeria, Enugu campus. I've said so severally. And I am the chairman of our local government and a former member of the Rivers State House of Assembly. I'd like to first and foremost align myself with the sentiments that have been expressed by the Right Honorable Martins Chike Ameule, the Speaker of the Rivers State House of Assembly, as to our continued faith in the judiciary. Judiciary has always been said to be the last hope of the common man. These days, most people have joked that it is no longer just the common man that has the last hope in the judiciary. Even the rich run to the judiciary when there are disputes. So yesterday, again, the Court of Appeal, in a unanimous judgment, affirmed what most of us had said is the correct interpretation of the law, that Justice C.M. Wale, ab initio, had no jurisdiction to entertain the matter for which he dabbled on and made the pronouncements that nearly would have inflamed the state. And that is why, listening to your colleague in the studio when she asked a question as to where all of this keeps the country, she asked if in a sister program this morning, are there issues that have been raised, constitutional issues that have been raised as a result of all of the things that are happening? Yes, of course. There are quite a lot of issues. What will happen to judges, judicial officers who knowing that they have no jurisdiction to hear a matter, entertain the matter, and go ahead to make pronouncements that are capable of inflaming a state or exacerbating an already exacerbated situation. So we thank God for the Court of Appeal. There is nothing on the way of Martins Amehule and his colleagues from continuing to make law for the good governance of the people of Rivers State. Recall that everybody knows that Section 272 sub 3 acts as an ouster clause that stops the State High Court from them entertaining issues that relate to the defection or otherwise tenure of members of the state as houses of assembly, and especially Section 68 sub G for those of the National Assembly members. So which gave rise to the case of Abegunde against Abegunle against Ondo State House of Assembly. The courts have made pronouncements in this regard, but we keep having the likes of King Lear in what reminds me of my literature when I read King Lear, one of the books written by William Shakespeare. Some others do have them. We still have situations like this where people...
Mr. Lloyd, if I may interrupt you here, you've aligned your sentiments with that of Mr. Amewule and on the position of the appeal court, that ruling on the jurisdiction of the State High Court on this matter. But is there no other case? Is this the only case that is before the courts? I don't understand that there is a case before the Federal High Court here in Abuja about the defection of the 25 members or thereabout from the Rivers State House of Assembly.
There are plethora of cases. What has happened in North is that soon after the political solution to these problems, after we met with Mr. President, and we all got back to the state, the governor of the state, with due respect, held a statewide broadcast where he told the state that nothing was too much for peace, and that all that had happened, including the eight-item solutions that were proffered to the problems in the state by Mr. President, was not a death sentence. Then, all of a sudden, we now find the government of Rivers State begin to sponsor people to approach the cause in different ways. So, in order that we have not less than 200 cases, as I speak to you now, if I'm correct, bordering on different subject matters.
Just hold on. The matter before the Federal High Court in Abuja was actually filed by Mr. Amewule himself. Do you know about that one?
That's what I'm telling you. There was a matter filed by Mr. Amewule, whose judgment was given by Justice J.K. Omotosho of the Federal High Court Abuja, and judgment has since been delivered in January of 2024.
All right, Mr. Lloyd.
Has been flagrantly disobeyed. The government of Rivers State continues to be in contempt of that judgment, because in the Omotosho's judgment, there were mandatory declarations, mandatory orders that were made. For instance, that the job of the State Assembly will not be hampered in any way. Funds to it will not be seized in any way. The governor will not be seen to be doing anything that will be inimical to the discharge of the functions of the State Assembly. So the governor and government of Rivers State have continued to be in contempt of the judgment of Justice J.K. Omotosho.
All right, Mr. Chidi Lloyd, I want to be able to, because we do have just a few minutes for this segment. Let's talk a bit about that judgment of yesterday. For many people, this is not a reinstatement of the 25 state lawmakers. This is a judgment on jurisdiction and not a reinstatement of these men. What's your take on that?
My take is that I just laughed. Now, what was the situation before the Right Honorable Amewule went to court? The Justice C.N. Wale came out and said he had expelled the Speaker and 24 others from the State Assembly. So if this is not a restatement, I wonder what it is. The Court of Appeal has nullified, that is the word, my sister, all that was done by Justice C.N. Wale, pursuant to the provisions of Section 272 sub 3 of the
So what actions do you think should, in your view, since you say it's a reinstatement, what should happen next with Amewule and the 24?
The Speaker and members of the State Assembly will hit the ground running and continue to make laws for the good governance of Rivers State. All
right, so let's talk about this conflicting. Let's talk about this Rivers State High Court. You just mentioned right now, that it's brought up, and my colleague, of course, on the morning brief talked about it. This has brought up the question that we've been asking about courts not having jurisdiction, making rulings that in the end have to be nullified, and then we have all of this going up and down. What do you think should happen in the case of this Rivers State High Court, that the Court of Appeal has said they didn't have the jurisdiction, and saying that it's only the Federal High Court in Abuja that has the jurisdiction to declare a seat vacant or not?
My sister, I watched you closely when you were discussing the Edo State issue. And I saw a senior lawyer laboring to avoid the questions you were asking, hiding under the view that he is part of it. Now, what will happen, my dear sister, is that the disciplinary measures of the judiciary should be activated to punish judges who continue to act or traverse their powers and bring the judiciary to public odium. It is so sad. It pains me a lot, especially as a lawyer that I am, that a man clearly knows he has no jurisdiction, except of course, it goes a long way to talk about the depth of some of these judges, with due respect.
All right. Well, we would like to.
How do you explain? How do you explain that a judge does not know that there is a fourth and fifth alteration to the Constitution? And it goes a long way to talk about the previous judgments of this same judge.
Let's see if we can bring in Mr. Felix. Mr. Felix Oguche.
Just a minute.
Yes.
You have another judge of coordinate jurisdiction in the person of Justice Okobule Basam, who approached with the same issue, says, I have no jurisdiction. I've been issued. You get the point. So it puts us in a lot of very dire position as lawyers and as members in the Temple of Justice.
All right, Mr. Felix Oguche, let's get your views as well on this particular matter. So you've heard from Mr. Chidi Lloyd. Where do you stand on all that's happened?
Dr. Chidi Lloyd, please. Dr.
Chidi Lloyd, thank you so much. Mr. Oguche, talk to us a bit about where you stand on everything you've heard Dr. Chidi Lloyd say.
Yes, thanks very much for inviting me. Maybe let me first of all correct one impression. My name is Festus Oguche, not Felix Oguche. I think the issue is very straightforward. That a court had been found to have extended or gone beyond its jurisdiction in granting an ex parte order. And the matter went to the Court of Appeal on that basis, and the Court of Appeal found that, well, you lack the jurisdiction to have granted it in the first place. And I think that's where the matter ends, because the issue before the court is on jurisdiction, and the court are taking care of it. In the first place, the lower court did not even go into the issue of the substantive matter, because we are still at the ex parte stage, interlocutory stage. The motion of notice had not even been heard. And ordinarily, I would have thought that all the parties should have been heard. Another of that nature cannot be granted ex parte, as far as I'm concerned. And there's been a lot of practice directions to that effect, that ex parte orders are not to be granted arbitrarily. I would say it is arbitrary, but then the Court of Appeal has come to give interpretation to the law. And as far as I'm concerned, that is where it ends. It does not give anybody any right or any power. It doesn't restore anybody or reinstate the 25 members of the House of Assembly who have defected back to their positions, because the Court of Appeal never said anything beyond the issue of jurisdiction. Once it has done that, it's a threshold issue. That's the end of the matter. The chapter is closed. Anybody who's aggrieved can go to the Court of Appeal, or if they want to maybe move a bit more appropriately, they can go and file a fresh action before the Federal High Court. for interpretation of the provisions of the Constitution. I would not say that the judge is totally out of the way. In spite of Section 272 sub 3, that particular provision is talking about vacancy, not necessarily defection. I think it is when the Supreme Court gives a wholesome interpretation to it that we begin to understand its entrails, to the nitty-gritty of what it means. Because I would think that issues of that nature must align with the structure of the state system, the judicial mechanism within the state system, even though there's a provision in the Constitution that also says that the National Assembly can look into the issues of vacancy, but vacancy may not necessarily pander to or pertain to defection. And the crux of the matter there is on defection. And I would say that Section 272 sub 3, even though it has come to the aid of some persons, is something that I would consider a misnomer, because we are trying to move away from the highly centralized political system we are in the federal structure that we are practicing, to something that will give the state some shade of authority. Issues concerning the House of Assembly should be matters within the jurisdiction of the state high courts. Well, be that as it may, the Constitution has said it, and the Court of Appeal has given its opinion, decision on it, and I know that a lot of people have contrary opinion, and we look forward that the Supreme Court will give a decision that will take care of it whole and entire. But to the extent that I understand, it doesn't give anybody any right, it doesn't give any of the parties, it doesn't give recognition to either of the two factions of the Houses of Assembly or the House of Assembly of Rivers State. The three-member structure cannot claim that they're entitled to a constitutional validity, and as well as the 25-member House of Assembly led by a neighbor. They cannot also make such claim, constitutionally speaking. I understand that so many other issues are cropped up, like you mentioned the matter before the Federal High Court that is pending. But that is the issue is very straightforward, that we cannot get something out of nothing. It's only God that created the world from nothing. Thank you.
Well, Mr. Guche, so what then is the implication of this decision of the court? So you have said now, on the one hand, that the court didn't quite talk about vacating or not vacating office. The court only spoke about jurisdiction. Now, it is also said in legal parlance, correct me if I'm wrong, that you don't put anything, you can't put something on nothing. So if the courts that vacated or purportedly vacated the seats of these lawmakers had no jurisdiction, what does that imply?
It implies that, first of all, that the issue of jurisdiction, like I said, is threshold, and it's at the apex of the constitution of the issues. If the court vacated the position of the lawmakers and their defection is still subsistent, a defection that judicial notice of will be taken, a defection that we are all aware of, even though they made a detour in the middle of the sea to say that they did not defect. It is all clear that there was a defection. That constitutional provision is self-executing. People prefer me to use the word self-executory, but that's not the appropriate word. It is self-executing. You don't even need any interpretation of the court to effect the provisions of that particular provision relating to defection. Once you defect from one political party to the other, if you are going to be an elective position, you have lost it. In the United States, in England, in advanced democracies, once you do that, in England, once a member of parliament jumps ship, the next thing is the conduct of by-elections. It happens automatically. So I don't think it is even necessary. Some of the parties have gone to court asking one such matter is before the Honorable Justice Woodbine of the Federal High Court here in Port Harcourt. Another is before the Honorable Justice Abdul Malik at the Federal High Court. Fill those vacant positions. I don't think it is necessary. That's being on the side of supplicity. And nobody did necessarily have to wait for anybody, to ventilate his right in court before elections are conducted. Upon the conduct of elections, they can go into a post-election adjudication process to challenge that election on the basis that there was vacancy. That's if you are convinced that there was no vacancy. So that there's a proviso to Section 191, if I'm correct, on defections does not make it automatic that all hands will have to wait. The system will have to stop for you to ventilate your rights in court for an election to be conducted. So as far as I'm concerned, the implication of that judgment is simply that the lower court lacks jurisdiction to entertain that matter. That decision is still subject to challenge at appropriate judicial quarters, particularly the Supreme Court, because people have contrary opinions like that to it. But then it does not restore anything, does not restore anybody, it does not cancel the defection already effected by the 25 members of the House of Assembly. It does not give them any right or power to be reinstated to that position or to be restored to that position. That's the crux of the matter, and we must understand it simply from the point of view that the Constitution has certain provisions that cannot be ignored, cannot be kept in abeyance, particularly that particular provision relating to political parties and the conduct of their members, particularly those ones that are elected and who wants to jump ship, who prefers to jump ship, particularly if they did it voluntarily. Nobody pushed them into it.
I'm not aware that
Thank you so much, Mr. Festus Oguche, a legal practitioner, a senior advocate of Nigeria. Thank you for joining us this morning. And Dr. Chidi Lloyd, former member, Rivers State House of Assembly, former lecturer at Department of Private and Public Law, University of Nigeria, Enugu campus, and as you said, local government chairman. Thank you, gentlemen, for coming in this morning. And that is where we'll say thank you for letting us be a part of your morning. It's been a fantastic 1 week running. It's been a marathon. And I think that's ending on a legal note. I will be spending the weekend thinking about all the legalities of that's going back and forth and the politics that there is out there. Thank you so much. I'm Neota Igbe.
I don't know what Aya did to deserve that stray bullet this month, but Aya, I am on your side.
It's not straight.
Have a great, it wasn't straight, it was direct. Have a great weekend, everyone. I'm Kayla Magwa.
Well, Kayla, maybe it's one of those things that the courts have to decide. I'm just hoping this time it will be direct and will not be confusing. Amaya Makide, do have a beautiful weekend.